I don't understand because I'm innocent. I don't know what's going on. I don't know what.
Listen, you've entered a not guilty plea, so there's a presumption that you're innocent, or a presumption you're not guilty. So
No, Mr. Salim represents him in one of those.
Mr. Salim
Can I speak for the record too?
Williams, finish now.
Yes, sir.
So I would like to put a few things on the record, Your Honor. My client had an offer from the state last week, and he did not wish to take advantage of that offer. My investigator and I went out to the jail, talked to him, went over things, explained everything to him. I gave him my advice, which was that I thought it was in his best interest to accept the offer. He refused that, and that offer was for 20 years with a mandatory minimum. He still has an offer today for 25 years mandatory minimum, and I've discussed it with him briefly over here in the box, and he's told me that he doesn't wish to do that. But considering the fact,
Your Honor, this man ain't even helped me in my defense. None of that.
Mr. McCarty, I told you I'd give you an opportunity to speak.
Okay. Yes, sir. Yes, sir.
Finish.
what I was going to say, Your Honor, is considering, I've explained to him that his exposure is in the 3365, the attempted murder case is a life sentence, and that he's further exposed in the 2756 case on the tampering to an additional 30 years, since it was a tampering with the underlying case being a first degree. So I've explained to him his exposure. I've given him my advice. I've told him what I think is best for him. And he, as is his right.
Hey guys, and welcome to today's video. What you're about to see is a powerful courtroom moment where everything hangs in the balance. This is the point where decisions become permanent and every word matters. As this hearing begins, you can already feel the tension in the room. On one side, the legal system lays out serious consequences. On the other, a defendant struggling to process what's unfolding in real time. This case quickly turns from routine procedure into something much deeper, revealing confusion, frustration, and the harsh reality of what happens when preparation meets resistance.
I really wasn't aware of that. You hear what he said?
Yes, sir. But
so let me ask you this. Before the judge is going to give you a chance to talk.
Okay.
But in light of the fact that Mr. Sullivan has made this new filing, and now you have your maximum exposure is 2 life sentences, do you wish to reconsider your choices with regard to accepting the offer?
I don't understand. I don't understand. And being that he's representing me, we haven't even worked the defense in this case at all, period.
Okay.
And plus,
let's take one thing. Do you understand that you've been off for 25 years in prison?
I don't understand, sir. Yeah.
Then yes, you do understand you have a plea offer for 25 years in prison.
I don't understand because I'm innocent. I don't know what's going on.
Listen, you've entered a not guilty plea, so there's a presumption that you're innocent, or a presumption you're not guilty. So that, regardless of your claims or the fact that right now we presume you not guilty, you understand the state has offered to let you plead no contest to charges, and it'd be a 25-year sentence. And I believe, what is it? Is it a minimum mandatory 25?
It would be a minimum.
Right here, the gravity of the situation becomes clear. The defense explains prior negotiations, missed opportunities, and the risks now on the table. This is the moment most defendants rethink everything, because the stakes are no longer abstract. We're talking about decades of freedom, possibly even life behind bars. You can hear how carefully the court tries to make sure the consequences are understood. This isn't pressure for the sake of drama. It's about clarity. Once these doors close, there are no easy reversals, only outcomes shaped by choices made today.
Yes, sir.
Raise your hand again.
Solemnly swear the testimony you're about to give is the truth.
Yes, ma'am.
All right, Mr. Cromartie, state your name.
Jamel Cromartie.
What are you asking for today, Mr. Cromartie?
This name of this contract does not refer nor identify the male standing in this corporation. I, Jamel Cromartie, being forced to go against my will in my best interest, my right of due process have been impeded upon. Also, my Fourth and Fifth Amendment right have been violated. I invoke my rights of the Constitution to protect me and my best interest. I invoke my Fifth Amendment.
Okay. All right, then you vote the Fifth Amendment right, so you're not asking to testify. What are you asking me to do?
First of all, I have the right to face my accuser.
Listen. What are you asking me to do today, Mr.
You
Camardi?
saying I don't understand.
Mr. Camardi, what are you asking me today? I'm gonna give you one.
I don't need him on my case.
Okay, are you at, listen, what are you asking me to do?
Or this one right here. This one, both two right there. I got some that's conspiracy on what they trying to do.
Okay, what do you want me to do?
Continue my trial.
No, sir, motion denied. What are you actually asking me to do? What are you asking me to do, Mr. Camardi?
A fair trial.
All right now, you're gonna get a fair trial. Is there anything you're asking me to do right now?
As the judge steps in, the focus shifts from offers to understanding. The court isn't debating guilt here, it's confirming awareness. This is a critical legal checkpoint. The system requires that a defendant fully grasp what's being offered and what's being risked. But instead of resolution, confusion takes center stage. Emotions rise, trust breaks down, and accusations begin to surface. What we're watching is not just a legal exchange. It's a collision between procedure and perception, where communication starts to unravel under the weight of fear and uncertainty.
To say yes, sir. I'm guessing you agreeing with me. I don't know.
No, I'm asking you a question. So you don't understand that, is that correct?
Understand what?
That you have been offered 25 years in prison if you pled no contest and that will settle your cases. Do you understand that?
I don't know how to answer that.
You're going to have to answer my questions if you want to represent yourself, sir. If not, I'm not going to find you competent to represent yourself.
Yes, sir.
Do you understand you've been offered 25 years in prison? Is that correct?
Yes, sir.
Okay. So when you said before you didn't understand that you were not being truthful with the court, is that
There's
correct?
a lot that's going on that I don't understand.
Listen to me.
Yes, sir.
You were not being truthful with the court, is that correct?
I'm not gonna say I'm being truthful.
When you
I
said
don't understand.
you don't understand.
You got to talk to me in a level where I got to
Yes, sir. I'm talking to you the same level.
But some of it I don't understand because there's some shit.
So you don't understand what's going on?
Half of it I don't.
How far did you get in school?
9th grade.
And you read and write?
Barely. I could barely spell.
Okay. And you understand if you represented yourself, you'd have to do everything a lawyer
I'm gonna
did.
do what I can that I've been trying to do.
Do you understand you'd have to do
I do
everything?
better than him.
Listen to me. If you want to represent yourself, you got to answer these questions. If not, I can't allow you to represent yourself. So
I ain't trying to make a fool of myself, but Yana, I don't.
Now things take a dramatic turn. The defendant moves from disagreement into confrontation, questioning representation and the process itself. This is where courtroom dynamics shift fast. Judges have to balance patience with control, while ensuring rights are protected without letting proceedings spiral. Requests are made, frustrations spill out, and suddenly self-representation enters the conversation. That's always a dangerous crossroads. Choose and go alone in a case this serious can change everything. The court slows things down, asking direct questions, trying to determine whether this path is even legally possible.
and we'll see you Monday morning and pick a jury.
All right.
Well, Mr. Clark, can I say something, sir?
Yeah, you can address your case also, the one you're representing yourself. Also.
Right. Yes, sir.
That's for the record. That's 23 CF 204.
Yes. Yeah. Well, I got a couple motions I want to file on that one, but
Okay.
about that case, so can I ask why am I being held without bond?
Sir, Mr. McCoy, we've gone over that. I revoked your bond, I believe, in the K2 case numbers because of the arrest. So I think we've already adjudicated that and litigated that. I'm gonna litigate it, but that's why you're being held without bond.
I mean, is there a reason though, sir? Like,
Yes, sir,
because held without bond?
Yes, because you were out on bond and you picked up another charge.
But I'm innocent on that charge, Mr. Clark. And I got the evidence.
Absolutely, you're presumed innocent on all the charges. I assume you're not admitting that you're guilty on the two charges that you're out on bond on. You're presumed innocent on all three of the charges.
So can I ask that the state has filed a motion to hold me without bond, Mr. Clark?
No, sir. I believe the court. I believe, and I may be wrong. I may have done it on my own motion.
You had a hearing in February, I believe it was February 24th, and then you addressed it also at our last hearing on October the 17th.
Here's where reality hits hardest. The judge carefully explains what it truly means to represent yourself, mastering rules, evidence, and procedure on the fly against trained professionals. Educational background and basic comprehension suddenly matter a lot. This isn't about pride anymore. It's about capability. You can feel the court testing whether this choice is informed or impulsive. These moments decide futures. The law allows self-representation, but only when someone is competent to handle it. And right now, that standard becomes the center of everything.
The patience with me, sir. I understand that's judges. They should be patient with their client, with litigants.
Well, I'm as patient as you. I'm going to be patient. I'm going to treat you just like a lawyer. And I'm treating you just like a lawyer. And when a lawyer goes to repeating themselves or re-litigating something that's already been litigated, I give them very little short leash. And that's basically what I've done to you. I've addressed that so many times. I'm not prepared to address it again today. So if you want to talk about something else, let's move on. But I'm not going to reinstate your bond today. Okay? Yes, because you picked up another charge while you were out on bond.
Well,
that is just,
okay.
and that, I know that you say you're innocent, and you've said you're innocent on.
Listen, I just want to say this one thing, Mr. Clark. One thing, but we can move on to the next thing.
Okay.
Okay. What makes me different from the person that you released last month?
I don't know.
I picked up a driving on suspended license charge.
I got no idea.
He had battery on a police officer.
Listen to me. I'm not going to compare you to other.
Battery on a police officer.
I'm not going to compare you to other cases right now because I can't remember. It's not fair to me. I don't know why I did what I did.
I've been in jail. This case been going on.
Let's move on. I've answered your question. What else is there? Go ahead.
Sitting in jail for 3 years, Mr. Clark.
I understand, but tell me what else. No, you ain't sat in jail for 3 years. This was the
yeah, for a few months when I caught that BS charge, but I got it all the time before.
With that evaluation complete, the court makes a firm call. Counsel remains in place, and the case moves forward toward trial. But the tension doesn't end there. Attention shifts to custody status and bond, reopening wounds from earlier hearings. The defendant argues fairness, compares outcomes, and pleads for reconsideration. The judge responds with consistency, pointing back to prior rulings and new charges. This exchange highlights a hard truth of the system. Once conditions are violated, trust erodes quickly, and rebuilding inside a courtroom is incredibly difficult.
File a motion.
Well, I got the motions ready right here.
Well, file it.
Okay, I'm about to file it. But my thing is, if it's already on the court's attention that the information that was filed on me was wrong, that's a fundamental error.
That's
impossible to
this
charge
is
me with
unsworn testimony. I got no idea, but file your motion, and we've got everything. We'll set.
We already been through that because I'm a charge before. I'm a case before you already corrected that charge. So why is?
Listen to me. I'm not arguing with you. This is a pretrial. I'll set your motions for December 19th. If you want to file your motions now and get everybody ready.
Right now, I'm filing. Okay. What about my? Oh yeah, back to the representation thing that we had.
Okay.
Okay. I have a copy of my transcripts.
Yes, sir.
And you said that I expressly requested counsel. I got a copy of my transcripts to prove that that's not true.
Okay. Well, you on what case?
On my 23 case, I got a copy.
You represent yourself on that.
No, but you made me redo it. I had you denied all my motions.
What is your relief? What relief are you asking?
My relief is that I want my motions to be heard that was denied.
December 19th
versus state.
Look, we're going to set the pre-trials for January 18th. Listen, Mr. McCoy, your hearing is over with today. I've listened to everything I'm going to listen to. We'll set your motions. If you want to file them right now, give the state their copies December 19th at 9 o'clock for the motion. I'm assuming it's a motion to reinstate bond. It may be a motion to
it's a motion for
dismiss.
Motion to discharge and the motion for notice.
All right, file them, and we'll set it for December 19th. We're going to set we're going to set everything for January 18th.
Let me get my motions ready. I ain't ready to be pulled out yet. I got to get a state.
No, sir. You can hand it to them, but this is your hearing over with today.
I can't get them my motions.
Yeah, that's got nothing to do with it.
All right, I gotta get them ready.
You just let Mr. Devontae McCoy sit in the courtroom and get his paperwork ready and get him to let him file his motions and give his copies to the state.
You have a nice day, Mr. Clark.
Huh?
You have a nice day.